Welcome to the HR Law Overview Training class. You will encounter various HR-related issues throughout your day-to-day operation within this company. We feel that you will experience certain topics more than others and have selected those topics as the basis for this overview training. Topics we will cover today are Equal Employment Opportunity Commission and the Civil Rights Act of 1964, specifically Title VII, Americans with Disabilities Act, Occupational Safety and Health Administration Act, Fair Labor Standards Act, Equal Pay Act, the National Labor Relations Act, and the Taft-Hartley Act. This training is designed to give you a general foundation for these topics. If you find that you have questions directly related to these topics discussed here today, or if you need any assistance or consultation with an HR-related topic, please do not hesitate to reach out to your human resource representative. The Equal Opportunity Commission is an agency that was born from the Civil Rights Act of 1964. The EEOC, as it's known, interprets laws and enforces laws to ensure that people are not being discriminated against. The vast majority of our dealings with the Civil Rights Act of 1964 seem to come from Title VII of the Act. In short, the focus of Title VII of the Act is to forbid discrimination due to race, color, religion, sex, including pregnancy, national origin, age, which is 40 and older, disability, and/or genetic information. What is not considered discrimination under Title VII of the Civil Rights Act of 1964? Those would be seniority systems, veterans' preference rights, national security reasons, job qualifications based on job-related test scores, a background or experience, and bona fide occupational qualifications, or BFOQs. So what is a BFOQ? Well, it's difficult to find a concrete definition for one, but to try and help define it are examples of bona fide occupational qualifications. So there may be a mandatory retirement age for a bus driver or an airline pilot, just for safety. Jobs that would require certain religious affiliations, for example, a Catholic priest. And also, the casting of actors based on race or sex in order to maintain authenticity. Is being a woman a BFOQ for jobs at restaurants like Hooters? Well, not exactly. So far, it has not been determined that being a woman is a legitimate BFOQ in order to be a server at Hooters or a Hooters-type restaurant. The company maintains that it is a BFOQ. However, every time they're brought to court on this matter, they settle with the party without going to trial. So why has this been chosen as an example? So while it may seem obvious what may or may not be considered a BFOQ, be careful of jumping to conclusions on this matter. Just because something has been established as a long-running assumption does not mean it is legal. Before starting the hiring process, please involve your HR representative to review the steps you intend to take during the candidate selection and interview process. Now, how is a discrimination case proven in relation to Title VII? So Title VII states that the burden of proof is on the plaintiff. They must show a prima facie, which is presumed to be true until proven otherwise, violation of an equal employment opportunity law. The most frequently used theory in order to try and prove discrimination took place is by proving disparate treatment. In disparate treatment examples, a company would have used different criteria to evaluate candidates or employees in terms of hiring and promoting. In short, the Americans with Disabilities Act of 1990, or ADA, ensures that employees will not be discriminated against because they have certain disabilities, but it also requires equal access or an acceptable alternative to buildings and experiences. In the workplace, the ADA ensures that an applicant or employee will be able to perform the job with or without reasonable accommodation. A reasonable accommodation would be to adjust a workstation so that the heights of the counters would not be too high for someone in a wheelchair, for example. Another reasonable accommodation would be job responsibility restructuring or moving the employee to a different role within the company that would better allow them to perform work. Now, not all companies are required to make reasonable accommodations for their employees. If they can prove an undue hardship, then they would not be required to adjust their facility. When considering an undue hardship, the size, resources available, nature and structure of the employee's operation is taken into consideration. For example, there would be no excuse for a company the size of the Walt Disney Company to not make a reasonable accommodation. However, a small family business may not be able to do so because it may be too expensive for them to accommodate the disability. The Occupational Safety and Health Administration Act. This act assigns OSHA with the task of setting standards and conducting inspections of workplaces to ensure worker safety. Employers must comply with OSHA and fix any violations that were discovered during an inspection. Employees are given the right and protection for filing a complaint with OSHA. Now, as a manager, if you learn of any employee that has submitted a complaint to OSHA, do not discipline them. This would be illegal. So we welcome OSHA to our facilities and will comply with their investigations. This includes not interfering when OSHA representatives try and speak with our employees, and will also make any changes to our operation and facilities that the OSHA investigator discovers during their investigation. The Fair Labor Standards Act establishes a minimum wage in the United States, as well as sets the guidelines for non-exempt employees to receive overtime of 1.5 times their regular rate after 40 hours worked in a work week. As you can see, the current minimum wage is $7.25 per hour, which was set back in 2009. Tipped employees must pay their Tipped employees must be paid by their employers at least $2.13 per hour unless their hourly wage plus tips does not equal the minimum wage of $7.25 per hour. In a case like this, the employer would have to they would have to make up the difference to get the employee up to that minimum wage number. The Equal Pay Act requires employees to pay men and women equally for equal work. According to the Equal Pay Act, the jobs do not have to be identical, but they must be substantially equal. And the criteria set by the Equal Pay Act to determine if roles are substantially equal are skill, effort, responsibility, working conditions, and the establishment. Even with the Equal Pay Act, there may be some instances where there are still differences in pay at the workplace, and these would be based on seniority or if there were a merit or quality of work raise system in place. If you discover that one of our employees is paid higher than the others and they're doing substantially equal work, then that employee that's receiving the higher pay will not have their pay lowered in order to correct the pay difference. Instead, the pay of all of the other employees who are doing substantially equal work will have their wages raised to that of the employee who is receiving the higher wages. The National Labor Relations Act, also known as the Wagner Act, gives employees the right to organize and engage in collective bargaining with their employer. In short, it gives the employees the right to unionize. The Act protects the rights of employees to form or join an already established union and to strike for better working conditions. The Act names things that employers cannot do to try and suppress the rights of their employees, which includes threatening the loss of jobs or benefits if employees try and unionize, threatening to close down and move the facility if employees unionize, question employees about union activities or their membership, spy on union meetings, grant wage increases to those who do not vote for a union as a means to discourage employees from joining the union. On the opposite side of this, the Taft-Hartley Act protects those employees who do not wish to unionize as a measure of ensuring they are not coerced by unions into membership. It also says that a union cannot try to have the employee disciplined by the company because they do not wish to join the union. It is unlawful to have all employees join a union unless that is a condition of accepting the job. For instance, if there's a union shop agreement. Also, the union cannot try and pressure another business to stop business or affiliation with this business with a shop that the union is having issues with. We want to thank you for taking this class, and we hope that you're able to come away with it with a better working understanding of some of the more frequent HR-related laws that you'll come into contact with as a manager here with this company. As we've stated, As a manager within this organization, you are seen by our employees as somewhat of a spokesperson for the company. What you say and do can have larger legal ramifications. If you feel that you need to consult with an HR representative or are unsure of a situation that you're in, please reach out to the Human Resources Department. We will be glad to spend time reviewing the situation and giving you the best practice advice on how to handle the situation you're in. Thank you very much.